that is the relevance of emerging real estate laws in India. As rightly mentioned earlier, real estate is comprising of all the properties, the buildings, etc. Now we're going to dive into a little bit of the basic terms, understanding what real estate actually comprises with, especially when you're practicing as an advocate or a lawyer or dealing with litigations. There are basic terms, I think, which are very important. I'm going to summarize few terms which are widely used so that you have an understanding of it. Now, the session will progress as we'll be talking about what real estate is, what are the important terms in real estate. Further, we'll dive into the real estate laws in India, which was rightly mentioned by the host earlier, being the Transfer of Property, Specific Relief Act, or the RERA. Then we will also analyze the impact of COVID-19 on real estate market, because obviously the real estate sector has been shook with the before math and aftermath of COVID-19. Then we'll delve into and touch upon the various types of deeds and agreement. And then we'll be going into the practical session where I'll be discussing the essential clauses with respect to the leave and license agreement, but it will be a residential agreement. And then we'll have a Q&A. Moving further, what is real estate? Real estate in general terms means the development of land and construction in relation to very specifically immovable property. Real estate here we'll be dealing with the immovable and not the movable property. Now, as throughout the years and as we are progressing towards the industrialization, there has been tremendous growth in the real estate sector in India as there are more industries, corporates, and also the population is growing in the industries like in the cities as well as in the residential and commercial complex. And with the increase of the population in the cities, the building construction has increased, and due to that also there is influx of commercial real estate law. Commercial meaning, for example, we see malls around, we see shops around which cater to our basic amenities. Now, real estate can be categorized as a large, huge, diversified sector which has different verticals. Now, when we call verticals, what is that? It is called the land or the design or the construction, development, investment, lending, etc. Now, for example, there is a vacant land and there are a lot of residential plots. There are a lot of houses, there are decks, there are trees, there are sewers, fixtures. Now, these are property which is bounded by the immovable property is treated as a whole of a real estate. So to put it in a simplified words, it is thus a property which includes the land, the buildings, the air rights above the land, and also the underground rights below the land. It's very important to understand when we are dealing with the land in a real estate, you also get the rights below. That's when the minerals, the mines, etc. come into picture. Now, real estate, if we talk in a very general terms, definitely means the development of land and construction in relation to very specifically, as I mentioned, immovable property. Now, there has been definitely growth, and that is what influxing the reason why real estate is going so further. Now, there are different real estate sectors which we namely called, and as I briefly mentioned in my introduction also, those are residential, that includes the newly construction houses and also the resale homes. Then we have the commercial real estate, which is the shopping centers, or we have the malls, medical and educational buildings, for example, your university. So these are coming under the influx of the commercial real estate sector. We deal with the industrial real estate, which includes manufacturing all the buildings and properties, and it also includes the warehouses. For example, these buildings are used on a commercial level, and also they're used for either researching or production or storage or distribution of goods in some or the other sense. And of course, the land is either a vacant land or a farming land or ranches. Now, obviously, there are different subcategories of vacant land. For example, some would be underdeveloped land, some would be in early stages of development, some would be subdivided into different areas. So moving forward to the next, that is the terms, important terms in real estate. Now we have carpet area. Now, especially when we are buying a property, I think the first question what everyone asks us is what is the carpet area or what is the built up area. It is necessary to have a basic understanding of these terms, not just because you are studying law, but also in a basic sense. Now, carpet area is known as only area that can be covered by an actual carpet. To put it in the simplest term, that means it is the area in the house where you can move or roam around or keep a structure. Structure, I mean either tables or etc. Now, you consider it as the net wall to wall area of the house, and it definitely doesn't include the area which is covered by outer walls or terrace or balcony, but it includes the inner layer of the house. And now when we talk about built up area, it's very interesting. Built up area is carpet area plus the area of walls plus the area of balcony plus the area of terrace. As in, to give you a simplest example, carpet area plus the remaining areas which we excluded, the wall area, becomes the built up area. So this diagram should give you a simplest area. Carpet area is the green one, which is the inner area. The wall area is the excluded one, and the built up area comprises of all the areas which is highlighted in the slide. Now, clear title. What do you mean by clear title? A title that is free from all the claims, from legal questions, all other encumbrances about the ownership of the property. To give you in the simplest form, when you go to buy a product in a market, for example, a toy, you always make sure that the toy is in a healthy and usable condition, right? Why do you do that? You want to ensure that you get the correct value for the product that you're paying. You don't want to pay for a damaged product or damaged toy at the end of the day, which you can't reuse or resell it further. So think of property as to the similar line. When you are investing huge amount of money, like lakhs or crores, why would you want to buy a property which has some or the legal actions tied to it, or it's not up to what it was given already in the brochure? So therefore, clear title is very imperative when you buy a land or a property, to ensure that at A, some people buy it as an investment. So you want to make sure that you can resell it something in future so that you can make profits. Or some people want to stay in it as a residential complex. So you don't want to be staying in an apartment, which, for example, you have been promised as an X carpet area, but you're not getting the carpet area as X, you're getting something else. So you are entitled to get what you are asking for in the simplest form, in the best health condition. That is a clear title. So when you buy a property, you will get a chain of documents. You see if there are any litigations attached to it. You see if the property is faulty in another way, or all the amenities which are supposed to be given, are they coming in or not? Moving further, we talk of the de facto position. Now, de facto position means constructive possession. Constructive possession in the sense that it gives you an actual physical possession of the property. Like that possession of the property is without any force or without any fraud. Now, these are the terms when you buy property. The builder always gives you an OC, that is an occupancy certificate, which certifies that you are now able to possess the property, that you can go and live in the property. Where we talk about de jure possession is called juridical possession. It means that the possession in the eyes of law, this may not be very effectively an actual possession, but in the eyes of law, you own the property, but can you physically access the property? You definitely cannot. It might be due to the amenities are not fixed in the apartment, or it is not in the readily available condition where you can actually go and live there. So that is the difference, a very minute difference, de facto and de jure possession. Moving ahead, yeah. So this is a slide which explains you in simplest terms. but we have already discussed that. So we'll be moving ahead to due diligence. In the simplest of the simplest terms, due diligence means verifying the authenticity of the title of the property. Now, we've already discussed what a clear title is. Due diligence means you are actually going to make sure by putting in efforts that the title of the property is clear. Now, when you start working in a real estate sector, you always come across the term as legal due diligence. That is, you want to investigate the property if there is anything in the records that prevents you from buying the property or selling the property or leasing out the property or mortgaging the property. Now, it means you ensure that the product that you're buying is in the best possible condition. If you want to own the property without any fault or fraud in future, and making sure it belongs to you, so you do the investigation. Mostly companies hire search registrars to find out any information about the property, so they pull out a land record of who has owned the property from the start when it was built till date, and then you verify each and every document, understanding if there are any covenants, negative covenants, which restrict the current owner from operating the property in the way he or she wants to. Now, title search, again, it is an examination of public record, or you can say investigation of public records in the history of ownership of a property to check for any unpaid claims, restrictions, or problems. Now, title search is a part of a due diligence process. Moving further, FSI. Again, this is a very common term which everyone hears, mostly when you are going to buy a property. Now, FSI, which is also known as floor area ratio, is the maximum area that can be constructed on a plot of land. Now, we've already discussed what a carpet area is and built up area is. So in that sense, floor space index comes in handy, because you want to understand, when you want to construct a building, to what extent can you actually use the area of land. Now, sometimes there are restrictions by either the state or the district, and also depending on the area. So it really depends from, again, what type of land you're dealing and in what area you're dealing. But this is purely dependent on the plot area, and definitely would vary from one locality to another based on factors such as the road width. Now, you can see public roads are a necessity. You need a road which gives you an access to a particular property or particular amenities. So while you're constructing your house, you always leave some area in front of your house to make sure that you give the access in order to enter the property. If you do not leave that area, even if you can construct a property which is hi-fi and also based with high amenities, it's not accessible. So the value of the property itself diminishes. Then with the FSI, we come across, so yeah, this is the area of the land. We have this whole of the built up area. So this is how you calculate what an FSI is. Calculations I'm not going to go into, but this should give you a fair idea what I'm trying to say. Now, TDR, we definitely come across the term TDR, that is the transfer of development right. It is more of a voluntary and incentive based program that allows the landowners to sell development rights from their land to a developer or any other interested party who can use those rights from their land to develop, or other interested party who can use that in a designated location. Now, for example, I'll give you a very simple example. It's like a cake, that's your land, and you cut out a piece of a cake and give it to someone who actually needs it. So you kind of trade that piece of cake for either value in compensation or another piece of land. It totally depends on the transaction, but you get some access with respect to the land, the piece of land that you are trading in the basically that means you're transferring your development right. The piece of the cake is your development right, and you're transferring it to someone else, which might require, now it can be, for example, for community open space or any natural or cultural resources. So either you do it with a government or you do it with any other person who wants or is interested in developing the property. Moving ahead is the term letter of intent. Now, the purpose of letter of intent is definitely not only to alert the property owner that you are interested in selling or leasing the property, but it also serves as a hint as what you bring to the table. Now, in a very simple form, it means that it is a non binding offer to buy a commercial place. I am a person who deals with properties, right? So when I want to buy a certain property from Mr. X, I will give him a letter of intent, or I will invite him over to discuss the commercial understandings of the property, as to, if you agree to sell me this part of land, I will pay you so and so in compensation. Then he might have an additional requirement that if you for example, construct a building on the part that I'm selling you, you have to provide me a flat at a discounted rate. So basically, you record a mutual understanding between the two parties who are interested in either selling the property or dealing with the property in any commercial sense. Sometimes it is non-binding, sometimes it is binding. It totally depends. But mostly letters of intent are non-binding if there are no legal promises involved. Now, no objection certificate, as it is the NOC. You always get a no objection certificate by related to the property from the either government departments or local authorities, which kind of gives you a stamp and which kind of assures you that all the plans which the builder usually submits at this before starting the construction of the property are in order. There, everything is legal, everything is agreed to the guidelines which are prescribed to the rules in force. In other words, definitely the authority tells the builder and everyone that they have no objection in the commencement of the construction. So that's a very essential document which a builder has to get, and which also buyers should make sure, which kind of gives you an idea that everything is legal and in order. Now, 712 extract or Satbara Uttara, it is again another very important document which contains all the details regarding the land. Now, when you want to buy a property, and you must have seen or come across in your house as well, people always refer to Satbara Uttara or 712 extract, which is a significant document confirming the status, the validity, the ownership of the property. And when you see a 712 extract, you can definitely find out who the owner is, or if there are chain of owner of the property, you can find out who the previous owner was. You have to find out how is the land type. Is it agricultural or non-agricultural? Agricultural refers to only where you can do the farming, and non-agricultural for the commercial purpose. What is the area of the land? What is the location? Now, in location, sometimes they are in an old traditional terms which they use it till date, but they always give you what is, if there are any well nearby, or is there any river nearby, what is the extent of the boundaries of the property. And then you also have any easements, as in, for example, if there is a farm located in the middle of the little bit narrow roads, you always have a narrow roads which people walk upon or take to and fro to communicate. So that is an access to road, which is an easement, which is very necessary. If you again block the access, the property is not in the best possible shape and it will devalue. Then you have any, for example, on 712 extract, people actually take out loans. So you can find out if there are any loans impending, etc., any taxes or any pending litigation. Any pending litigation, and if the 712 extract is updated, which always it should be, it will give a reflection about the whole basic idea of the property. For example, you are doing your own due diligence, to put it in the most simplest form. Now, when we talk about property card, now it is also known as Mal Matta Patrak, or it is a government certified property ownership title document in Maharashtra, very specifically. Now, property card acts as a record of right, that is ROR, which provides again a detailed information about the land and history of the whole property. Now, in Maharashtra, property card is used by the local authorities very specifically to establish ownership in urban area, while the rural areas issue 712 extracts. Now, when we talk about property card, 712 extract, they do both the same thing. They give information about the property, but property card very specifically provides information about the ownership of a property and history of land holdings located in urban areas only. And when we talk about 712 extract, it gives you an information for rural areas. Now, the basic is the same, but only the application is what it differs. Moving ahead, when we talk about the real estate laws in India, as mentioned before as well, there are different types of real estate laws in India, and those include the Transfer of Property, Indian Contract Act, Indian Easement Act, the Registration Act, RERA, that is the Real Estate Regulation and Development Act 2016, and Indian Stamp Act. Of course, there are more real estate laws, but I will be touching base upon the basic of these real estate laws very specifically, because these are the ones that you come across in day-to-day transactions and amongst the other laws. And also, once you understand the basics of these, it's very easier to navigate and run through the other laws as well. So, real estate laws, what does it mean? Very simply, real estate laws are the rules and regulations that regulate each and every aspect of a real estate as well as the property transaction. Now, there are so many requirements that are involved in real estate transaction, be it acquisition, selling, leasing, transfer, foreclosure of a property. So it's very necessary that the transactions are protected through a uniform laws, and real estate laws are very specifically in place to safeguard the rights of the property who owns it or who purchases it or who is selling it or who is leasing it. Now, when we talk about laws, of course, laws are in place because there are some issues already existing in real estate, right? Now, when we talk about the issues, it might be either the legal contracts and the agreements that we exchange and sign while dealing with the transaction. It might be any dispute resolutions relating to real estate property, either distribution or possession. Also, it could be buying, selling, acquisition, leasing, or disposition of different types of real estate properties. There are again the taxation issues which are concerning the real estate plays. There are, sometimes you just want to prepare a plan, you want to monitor the construction of a real estate site, so there are agencies there. So, and again, you draft all the types of different deeds or contracts for real estate transactions. So these are the basic issues which are highlighted when you actually deal with the property transaction. So that's why you need these laws in place. Now, since I mentioned you the laws, you can relate to the laws which are already displayed in the screen, because we'll be dealing with contract. That's why the Indian Contract Act. Easement, it gives you right and right to access to the property. Registration is necessary to ensure that the legality is completed. Real estate Regulation and Development Act is again important because it gives builders and the homeowners a confidence to buy more property, to invest in property, and also the builders to abide by the rules and regulations, because there are a lot of frauds and everything going on. And Indian Stamp Act, because you need to pay the necessary stamp duty. And of course, Transfer of Property Act, that's the main heart of the real estate because it deals with the immovable and movable property. Moving ahead, what is a Transfer of Property Act 1882? Now, in this act, the property is classified into two types, that is the movable property and the immovable property. Now, when we talk about TOPA, It deals with the transfer of immovable property. It definitely does not apply to transfer by the operation of law, such as transfer of immovable property, which is necessitated by order of court or insolvency or forfeiture, etc. It deals very specifically with the transaction aspect of it. Now, when you talk about immovable property, it includes land, benefits to arise out of land and things attached to the earth or permanently fastened to anything attached to the earth. Obviously, this definition of immovable property is not exhaustive, but it gives you a fair idea what it is. And when you talk about movable property, it says that it could be the standing timber, growing crops and grass, fruit upon, and juice and trees and property of every other description except immovable property. So, whatever doesn't include immovable property is movable. This is what the basic ideology is when we talk about that. Now, Section 5 of the Property Act very specifically, the Transfer of Property Act defines an act by which a living person conveys the property either in present or future to one or more living persons, either to himself or to one or more other persons. And to transfer property is to live with and to perform such act. Now, when you talk about living person, it definitely includes a company or a association or a body of individuals, whether incorporated or not. When we move to a practical session, when we talk about the name clause, you will always find some things in the bracket if the property could be transferred further in succession or to the nominees or not. So, which should give you a fair idea. And that's why it's important to understand what is the definition of a living person also. Now, when we talk about transfer of property under Section 6 of the Transfer of the Property Act, those are sale, mortgage, lease, or gift. Now, this act deals with the transfers of property by act of parties, like sales of immovable property or mortgages or charges, leases of immovable property, exchanges, gifts, and actionable claims. Now, according to Section 6, any property of any kind can be transferred. Now, how can they be transferred? This is what we're going to learn when we deal with kinds of transfer. Now, sale. Sale is a very common term. You buy and sell the property. So, according to Section 54, sale is a transfer of ownership, which in exchange a price is paid, or it is partly paid, or part promised in future to be paid. Now, the rights and liabilities of the buyer and the seller of immovable property is detailed in Section 55 of this act. Now, why do we say exchange? When exchange word is there, it's very important that a consideration, that is a price amount, is included. Is it necessary that you pay the price immediately? No. That's why the terms price paid or promised or part paid or part promised are included. For example, if I have to buy a property worth X crores, for example, at the moment I do not have the liquidity of the same. What I'll do is I will take out a loan for a few lakhs, and the remaining I am paying the person in cash or in check through my bank. So what will happen is, in my document towards the end of it, what they will write is so and so amount received upfront, the rest of the amount will be received from the remaining months of from so and so time. So am I paying all the amount upfront? No. That's how transaction works, because not everyone has the liquidity to buy the transaction, and that's when the loan, the mortgage, or trying to, or the TDR transfer comes in the picture. Now, when we talk about mortgage, according to Section 58, mortgage is a transfer of an interest in a specific immovable property for the purpose of securing the payment of money advance, or to be advanced either by way of loan, an existing or future debt, or the performance of an engagement that may rise to a pecuniary liability. Now, Mortgage is, for example, I am giving you my property for X amount of time, unless and until, depending what the transaction is, either I take a money against it and until I pay you back, you have it. Or if I owe you already some money, I'm going to keep it until I can actually trade that transaction amount of money, or just, hand it over. So it really depends what the commercial sense is when you actually mortgage a property. Some people mortgage a property for taking out loan for buying a property. Like our first one is the sale. So they do take out a mortgage to buy a property. So the commercial sense obviously differs, and it again depends where and how the term is used. Now, the transferor is called the mortgager, and the transferee is called a mortgagee. Now, the principal money and the interest of which payment is secured for the time, or time being, is called the mortgage money. And any instrument, for example, in which the mortgage is transferred, is called mortgage deed. Instrument refers to either the deeds or agreements. So the recording the commercial understanding which gives a legal point of view is known as an instrument. So that is known as the mortgage deed. Moving ahead, we will talk about lease. Lease is a term which everyone mostly has come across, leave and license, or the property is on the lease. Now, according to Section 105 of the Transfer of Property Act 1882, a lease of an immovable property is a transfer of a right to enjoy such property made for a certain amount of time, which can be either express or implied, or in perpetuity, or in consideration of a price paid or promised to be paid, or of money or a share of crop service, or any other thing which has a value, to be rendered periodically or on a specific occasions, and which is to be from the transferor to the transferee, and who accepts the terms of such transfer on the same. Now, this was a commercial definition, and it was important to understand, to go through it in a way. You give someone a property on a lease, it's more like transferring an ownership, but you don't actually transfer an ownership for perpetuity. You transfer it for a certain amount of time. The restrictions are less. When you talk about license and lease. License, I'm giving you a permission or a license to use my property, and there will be a lot of restrictions mostly. When you talk about lease, I will give you, it's more like similar transferring the ownership, but you don't actually transfer the ownership, but you give them more rights, more than any person who would have gotten out of a license agreement. Now, again, the transferor is called the lessor, the transferee is called the lessee, and the principal or the premium amount which is paid, or the everything that is paid, is called the rent. That's why most of the commercial properties are on a lease nowadays, because it's always effective to lease out a property than to actually own a property. And now, registration of this property, if it is from year to year, registration is not necessary. But if it is more than that, a registration of the property is required. Now, a lease of the property for any movable, like property, from any term exceeding 1 year or reserving a yearly end, again, as I said, should be only a registered instrument. So less than a year or up to a year, registration is not necessary. More than that, registration is necessary. Gift is a term again we come across usually when families are involved, or someone wants to gift a property, or wants to gift it in a wedding, or just to pass it on to their sons. So instead of actually going son or daughter, usually when you actually going through a specific route, or creating a transaction document to either sell or buy a property, you actually gift it, because then registration, stamp duty, everything, you kind of save the money on that. Now, a gift is a very common mode of transfer of property. It is a transfer of certain existing, either a movable or immovable property by one person to another. Now, it's very important that the transfer should be made voluntarily and without consideration. So when we talk about sale, mortgage, lease, usually a consideration is included. That means a price that has to be paid in the form of principal amount, or a rent, or a consideration. Here, it's very essential that there is no consideration involved because it's a gift and it is made voluntarily. Now, the person who is transferring the property is called the donor. The person to whom the property is referred or received is called the donee. Now, the donee, it's very essential when a transaction is involved and a gift is involved. The donee must accept the property during the lifetime of the donor and while he is still capable of giving. If the person dies and the donee has not accepted the property, then mostly the transaction is not complete. So it's very essential that the donee accepts within the lifetime of the donor the property as a gift, and in case he doesn't, the gift is void. Having understood what property is, what are the terms relating to property, when you call a transaction, what is a transaction, what are the different kinds of transfer include, we can move ahead to understanding, which leads to the Indian Contract Act 1872. Now, why a contract is essential? Because when you do a kinds of transfer, the base for transfer is your contract, is your instrument, is your deed of mortgage, is your like gift deed. So it's very essential to record the commercial understanding between the two parties and give it a legal effect in the legal sense. For example, if something goes wrong, I can go to the court and take out my remedies. So it's very imperative that you record the commercial understanding of the two parties dealing with a transaction, be what may be the kinds of transfer. Now, what is a contract? In Indian Contract Act 1872 doesn't provide a very straightforward definition, but it defines it with certain terms. Now, Section 2H of the Act, the term contract means an agreement which is enforceable by law. Now, again, according to Section 2E, every promise and every set of promises forming the consideration for each other is an agreement. Now, generally, the real estate transactions begin with an agreement between the parties, as understood earlier. The legislation definitely specifies when a party can be said to have a property or when a person is capable of entering into a contract. Now, a contract which is pertaining to real estate can be entered into by an individual who is definitely not a minor or of an unsound mind, but an individual, partners of a firm or a corporate body, a trust, a sole corporation, the manager of an undivided family, or even a foreigner, that is NRI. All the requirements of a valid contract, that is the consideration, intention of contract, and validity under the law of land, definitely must be satisfied. So the essentials of the contract, to make it a contract, what are the conditions? A person or a group of people must make a proposal to another person or a group of people to ask them to do or abstain from doing a certain task. That means recording a commercial understanding, what to do with the property, what not to do with the property. Then when the person or group of people assent to the proposal, it is said to be accepted. You understand what they're commercially proposing, and if you agree to it, you accept it. Now, this accepted proposal, which is in the air, which is not recorded as of now, signifies establishment of a promise in which the property making the proposal is said to be the promisor and the party accepting the proposal is said to be the promisee. Now, when each party fulfills the condition of a promise, an agreement between them is said to be established to record the commercial understanding. Now, when the agreement between the parties is enforceable by law, it is called as contract. Thus, a contract is established between the two parties. I know this is a very simple definition, but it's very imperative that we go into understanding what makes it a contract, because while recording the understanding, that's when something or other goes wrong, or that's when you have to make sure that you represent the best interests of your client and you fully justify it. If something goes wrong, you can actually fight it in the court of law and give your client the best justice, or best secure the best interests of your client, and that you can do only when you record the understanding very correctly, not just your understanding, discuss what is who can contract, how to contract, essentials to make a contract, and how the contract is done. Easement Act, moving to an Easement Act, we need to understand what is an easement. Firstly, Easement Act deals with either the easements and the license. An easement is a right which the owner or occupier of land possesses as such for the beneficial enjoyment of that land to do, or either to continue to do something, or to prevent and continue to prevent something being done, or in respect of his own property. Now, let's assume there are two landowners, A and B, owning the property X and Y respectively. Now, in this situation where a property of A, X is in a position where there is no room for A to access X by any other means except from the property of Y of B. Now, in this situation, it is very imperative that you record and you also make sure that B will have it in accordance with the Act, which is referred to as an Indian Easement Act, provide some part of the property Y for A to access its own property X. Now, this right which A enjoys over the property of B is known as easement. Basically, easement that gives you a right to continue doing, that means you can keep continuing accessing the property. Now, sometimes what happens, there are two neighbors, there is one small property which belongs to neighbor A and neighbor B. So what happens, the neighbor A doesn't want neighbor B to access the property through the road where the property is located in between, right? So what will the person tell? That you cannot come through this route, but this is an alternative route that I have provided. Now here, the only special difference is property owner is telling you you can't do this, but you can do this. Now, if property owner has given strict instructions to prevent him from doing something, it is very imperative for the neighbor to also understand and comply with that, because the main motto is to have the access to the property. It does not matter. And the dominant one actually determines how and when the property can be accessed, or how and when an easement can be given. Now, Section 4 of the Act states very specifically that the land for the beneficial enjoyment of which the right exists is called the dominant heritage, and the owner or the occupier thereof of dominant owner. Now, the land on which the liability is imposed is called the servient heritage, and the owner and the occupier thereof is known as the servient owner. Now, Section 5 of the Act deals with also continuous, discontinuous, apparent, non-apparent easements. Now, continuous easements, quickly, it is are the ones whose enjoyments may be continued without any intervention of any human conduct or act of man. Now, there is no human interference whatsoever by any man, and it adds special quality to the property. Discontinuous easement is the right to enjoyment where human interference is required. That is why it's called discontinuous. For example, it can be any act which is human act is done on a servient heritage. Apparent and non-apparent easements. An apparent easement is the one in which the existence can be seen through a permanent sign. For example, if there is a canal outside, you can actually see that, you can access it. Now, there's a drain from A's land to B's land, and from where there it led to an open yard. Now, this is very visible through a clear inspection and is also very apparent easement. When we talk about non-apparent easement, it could be just opposite to what apparent easement is. That means the kind of easement which is not visible until and unless a thorough inspection is made. Now, there is no permanent sign as such as it is in the apparent easement, but the right in use is not only visible, you need to access it through a very specific, thorough investigation, but it is also known as an invisible easement. For example, now A's right annexed to A's land to prevent B from building on his own house. It's something, will be in the property description or property documents, because it prevents the other person from doing something, and it cannot be seen unless and until it is specifically required. Now, conditional easement, like any other legal right, are subject to some either conditions or restrictions. Their covenants come in. The covenants can be positive, negative. Positive are the ones which usually are in the favor of the person. Negative are the ones which are mostly restrictive in nature. Now, moving ahead, license, Section 52 of the Indian Easement Act 1882 definitely defines license in the best term, which is a grant by one person to another to continue to do something on the immovable property. Now, it is essential that in license a permission is given, as mentioned earlier, right? If a permission is not given, then that would be an unlawful right, and which does not amount to an easement or an interest in the property. Now, Section 52 definitely doesn't require any consideration, either material, non-material, to be an element of license, nor does it require the right under the license must be by way of contract or as a result of mutual promises, etc. Thus, a license is defined under Section 52 very specifically under easement, which gives you a right to go over the property. Now, what is essentials of license? Whom can grant them? What is it, express or implied? When can it be revocable? You can find it under the sections. It's pretty self-explanatory. Moving ahead to the Registration Act of 1908. Now, registration is the process of recording a document with a recognized officer and to safeguard its original copies. Now, any document, whether binding or non-binding, shall be registered in a required manner, which is laid down already in the rules of law. Registration of every document is not necessary, but doing it helps because it kind of affirms the authenticity and helps in avoiding legal process. As mentioned earlier, when we were discussing and talking about license, when the property is licensed for like less than a year or up to 1 year, registration is not necessary. Now, what is the purpose of the act? The purpose of the Registration Act, amongst other things, is definitely to provide a method of public registration of document so as to give the information and the people in large. You can take out any document if you are the owner or any way associated to it, because it is recorded publicly. Now, Section 17 of the Registration Act provides for mandatory registration of certain documents, which are the gift deed of an immovable property and non-testamentary instruments. It is very necessary that these documents, amongst the other ones, are. Now, optional registration, we have adoption deed, will, power of attorney with respect to movable property, certified sale granted, promissory note, agreement of mortgage. So the Registration Act is pretty self-explanatory. You can just go and look into it, and then you need to find the deed of instrument that you want to register, and you can find the details regarding it. Is it mandatory? Is it not? Is it optional? Some states give it again. It depends from state to state as well. Now, when we talk about RERA, that is the Real Estate Regulation and Development Act 2016. RERA is and definitely act passed by the Parliament in 2016, and it came into effect fully from 1st May 2017. It establishes an authority in each state for regulation of the real estate sector and also acts as an adjudicating body for speedy dispute resolution. Now, RERA is a central act, and it is a medium through which the union has entered into state subjects like land. And one of the primary reasons RERA was enacted was to safeguard the interests of the buyer, to provide transparency, accountability, either domestic and foreign investment in the real estate sector, either provide uniform regulatory environment to ensure speedy adjudication of disputes, promote orderly growth through efficient project execution and standardization. Now, the key provisions of the Real Estate Act are, to provide transparency, to protect the interests of the promoters, buyers, real estate agents, establishment of the real estate appellate tribunals. After RERA, if you do not get the necessary relief, you go to the appellate tribunal. It also gives a mandatory registration to all the projects with the size of minimum 500 square meter or 8 apartments, which need to be registered with the regulatory authorities. Now, liability, developers' liability to repair structural defects for 5 years and cap on advance payment. For example, a promoter is a person who wants to build a building. So he cannot accept more than 10% of the cost of the plot or apartment or building as an advance payment. So, RERA Act has actually done what? It has given a transparency to the buyers as well as the builders. Buyers, it promotes more interest and gives it an medium to invest more, and also make sure that they are not frauded at the end of the day. And builders, it has put strict rules and regulations which they have to follow, which increase the efficiency. For example, if I'm buying a product, if I'm going to a toy store, again coming back to the example, I am removing the toy, I'm seeing if I can, it's functioning properly, I'm putting it the cell and everything. So that's what RERA does. When it comes to property, RERA makes it transparent. How? The buyer or the promoter has to upload all the documents, the plans, architectural plans, the OC, each and every document which is necessary, they have to upload it on the online portal. Now, every portal has given every project a special number, or it's registered by the name. So if I'm trying to invest into some XYZ group of companies to buy a property there, what I can do is go on the RERA website, put the name of the property, everything, including the name, detail, and house number of the promoter or the builder, it's literally displayed. The documents, for example, the basic agreement of sale, which is a primary document to record the understanding, that sample model is also there. Any documents or verification, for example, like title of the property, it's there. OC, it's there. So any document you need, you will have it. Now, the concept of 70-30 ratio. Under the section, the promoter is definitely required to deposit 70% of the amounts realized for real estate projects from the allotee from time to time, and it should be deposited from the separate bank account in a scheduled bank whatsoever. And the remaining 30% can be used by the promoter for any other purposes. Now, what does it does? The 70-30 ratio kind of instills a confidence in the buyers, because 70% of, as we saw earlier, 10%, more than 10%, the promoter or the buyer cannot charge over the deposit money, right? So once that money is taken, he or she has to deposit into a scheduled bank, where all the money which is withdrawn, you have to specify the reason why it is withdrawn. So 70% of the money, you can actually audit it for what purposes the money was taken out, and that money is of the people who are willing to buy an apartment or something. So they can definitely audit it and see where the money is going and how. 30% is usually saved for the uphold cost, for example, the laboral cost, or there are some here and there mere expenses, so the promoter can spend in that. So I think 70-30 is a very good challenge, in a good sense, where the developer or the promoter is challenged to keep the transparency between the builders and the buyers. Now, what if the allotee fails to take possession of his apartment? Now, what happens is, I have paid all the deposits, right? And when the time came, if I have to take the possession, and at the last minute, I'm like, listen, I don't want to take it. Even though I've paid it, can you please refund me the money? And can I withdraw from the project? Is it allowed? So it is already said that the once promoter has received the OC, that is the occupancy certificate, and is ready to give the possession of the apartment, the allotee has to complete its payment and formalities and take possession of the flat. The allotee cannot withdraw it. So I wanted to very specifically mention this case, because it kind of gives an confidence to buyers that once they're putting in the efforts, the money, and trying to implement what it was promised to the buyers, it is the responsibility on the part of the buyer also to fall through his promise. Like, the responsibilities are divided, very transparent, and both of the people have to fall through. So I think that is one of the great things that RERA Act as a person has done, because before RERA, it was MOFA, MOFA, but there were a lot of frauds going on. There was not a lot of transparency. So the government had to come up with something to build the confidence between the two parties. Now, Indian Stamp Act 1899. Now, the main purpose or the basic purpose of this act is to raise revenue to the government. Now, Indian Stamp Act 1899 is a central enactment, and states definitely have the powers to adopt the Indian Stamp Act 1899 with any amendments from the time to suit the transactions in a particular state. Now, the main purpose is to generate revenue, is to give the Stamped Act as the valid evidence in the court of law, and it also makes payments of stamp duty on some document compulsory when in return makes those documents kind of legally valid and authentic. Now, any document mentioned in Schedule 1 of the Stamp Act in force at the time of the execution of the document uh, is chargeable as prescribed in the already mentioned in the schedule. Now, the schedule includes a list of affidavits, lease, memorandum, articles of company, bill of exchange. So when you're trying to figure out what a stamp duty is, you just go to the Stamp Act, and at the behind there is a schedule. You look for the document, and it will give you all the details as to is it chargeable, how much is the chargeable, and again it depends from the state to state. So when you're trying to look for it, it's very necessary to make sure the state that you're looking for and the document where it is getting registered is correct. Now, there are two types of stamp duties. One is impress stamp and adhesive. Impress is by process of engrossing or engraving or embossing. Now, the labels in impress stamps are definitely fixed, and these impressions are done by franking machines in the bank. Most of the documents you do franking in the bank, so that is what it is referred to. Adhesive are ones which kind of are stuck on the top of the document. You can call it as a postal stamp, which have a limited application, or non-postal, which are revenue stamp or court fee stamp or insurance policy stamp, etc. Now, when to execute, the instrument has to be executed in India, must be stamped before or at the time of the execution. Now, the instrument which is executed out of India can be stamped within 3 months after it is first received in India. Or if it is a bill of exchange or promissory note made out of India, it should be stamped by first holder, like in India, before he presents for payment or endorses or negotiates it. Now, sometimes when the instrument is not duly stamped is inadmissible in the court of law, but it has following exceptions. Not every document again has to be registered or stamped. These are the exceptions. Like, what will happen is document can be accepted in the court of law. Sometimes a receipt which is not stamped can also be accepted as an evidence, just to record that something was paid. Maybe the penalty or the validity will differ. If any instrument is not duly stamped, then you can give a penalty of 10 times the difference on the duty, and a different contract will be admissible if any one contract is admissible as per proper stamps. For example, there are 10 pages in a contract, first few are stamped and the rest are not, then it will be given as an example exception that it was missed by mistake, and it will be counted as it. Now, stamp duty on instruments, Schedule 1 provides everything. This is just an example of how it is. You have the state, you have the rate of the stamp duty, and then you have the applicable law. It's very necessary to see that which is the applicable law very specifically. Now, talking about impact of COVID-19 on real estate sector. Now, real estate sector, which was already struggling to reemerge from the past turbulence of different structural changes or policy reforms or the liquidity crisis, was already set to witness again another major fallout. Now, that is our COVID-19. Obviously, it had a very major impact. It had a major impact because property is immovable, right? And the valuation of the property depends on how the economy is functioning. Now, when the economy was into a standstill or is functioning less, the property value differs, the inflation rises. Now, when you talk about commercial and residential property, when there are crises like this, I will not be buying a residential property. I will not even be investing or considering investing in a residential property. Whereas in commercial property, which was already listed in the market, what had happened is people were not able to pay the rent. For example, if I've given my property on leave and license, I'm not able to pay the rent because the property was shut, it was not used. Then you must have come across, there were so many debates as, is a landlord and like, can a landlord enforce a payment of the rent due during the period of COVID times, or is tenant compulsory need to make the payment in the times of coronavirus? So these are the kind of arguments and debates which were facilitating around, and that was shows that how majorly real estate sector was impacted in general. Now, one good thing out of the pandemic and the impact was, usually there are a lot of commercial properties in the market for a sale. I'm giving a practical overview, but due to the COVID-19, everyone who was trying to launch the residential projects immediately launched it, and the value had been decreased. So anyone looking for an investment during those time, it was the best investment they could make in a residential property, whereas commercial sector was struggling a lot because the malls and the leave and license agreement were impacted because there was a lot of fallouts going on. Now, a very natural question is how to deal with that. I think most of them took a midway where you negotiate with the landlord and the tenant and try to make them understand, legally, are they supposed to pay the rent? Yes. But owing to the national crisis, what they did was they took a midway where the rent was either reduced or the rent was not increased after a certain period of time, to ensure that the relationship between the landlord and tenant is also secured. So now we'll talk about the various types of deeds and agreements. Now, those are leave and license, development agreement to sell, memorandum of understanding, agreement for sale, and sale deed. Now, several transactions affect immovable property in the form of these type of agreements. Now, when we talk about leave and license agreement, it is a document that bestows the licensee with the permission to occupy the license's property. We already mentioned that it is different from lease, as lease creates an interest in the property, whereas license gives you a right to enjoy the property, like permits gives you a permission. Development agreement is a voluntary contact between a local jurisdiction and a person who owns or controls the property within the jurisdiction. Now, for example, if there is a vacant land, I own a vacant land. If I don't have the resources to develop the property or build a residential or commercial contract on that, complex on that. So a person comes in and offers me, we can jointly develop the property, as in he will put in the financial means and I will give my land, and then you record the commercial understanding, and that's how mostly the projects are done. So that is a development agreement. And also there are joint development agreement where the interest of both the parties differ. When we talk about agreement to sell, that is ATS, and agreement for sell, that is AFS, it's a little slightly different term. And agreement to sell is an important document in the process of sale and purchase of property. This agreement also contains like the terms and conditions agreed between the parties and definitely binds them. It is an execution of a sale deed. For example, first you do agreement to sell, and then you do a sale deed. It's like kind of recording the intentions of the parties, and further when you proceed with the transaction, you do a sale deed to finalize the transaction. MOU is kind of mutual, again, accord of issues and recording the understanding. If there is some things to be done, for example, when you want to buy a property, but there are some prerequisites that you want it to be made, so you record it to MOU saying that once you clear out these conditions from my end, I will go ahead and buy and purchase the property. For example, it is intentionally recording and understanding that I will buy a property once you clear out so and so conditions, and the intention has to be legally binding for sure. Now, when we talk about agreement for sell is an agreement to sell a property in future. Now, this agreement definitely specifies the terms and conditions under which the property in question will be transferred. Now, this TOPA again regulates the matters dealing with the sale and purchase of the property and defines for the contract for sale or contract and agreement for sale under. Now, a sale deed again is a legal document that proves the seller that has transferred the absolute ownership of the property to the purchaser. Now, through this document, the rights and interests in property are acquired by the new owner, and it contains all the basic details of the property description, the sale amount, etc. Now, these are different clauses in the leave and license agreement. I will walk you through a actual leave and license practical draft, and I'll be explaining that to you. One second. So again, as mentioned earlier, we have the name clause, we have the, yeah, we have the name clause, we have the recitals, we have the operative clause. Then we go ahead to understanding a signature clause, and that's the end of it. So this is a sample of a leave and license agreement, which is residential. Now, what happens is you put the name clause between whom and whom like the agreement is made. Then you always mention the PAN number, the age, who is he, from where is he, and also define the terms in the bold letters. For example, here it's the licensor. And this is very important, which expression shall meet and include his heirs, executors, administrators, and assigners. This is something which will depend if it is a corporation, a person. Here I'm taking it as a person, and that's why I've mentioned this. But this is a very important aspect. For example, if the licensor dies, does the property succeed further or does the contract end? Then we include the licensee after the licensor. Again, it's very important to include this clause. Recital. Now, recital is basically recite what is the background of the property, where the property came from, how did it come into a legal scenario, who was the property, what did you do ahead, yeah, what did you do ahead. So basically you recite what is there on the property, what from what date to what you want to do, what are the terms and conditions. And in operative clause, you actually put down the terms and conditions. For example, the period, the rent, the maintenance charges, the use, the alteration, no tenancy, inspection, cancellation, etc. Now, after putting in the operative clause is very important, because it kind of records the understanding, like I will pay you an XYZ rent for this month, I will pay you so and on this date, then this month. So you kind of record a commercial understanding between the two parties. A schedule is again an important part. It kind of gives you what is the premise, what is the extent to which the property is leased or on a leave and license. And a signature clause, again important, it's very necessary that you have two witnesses in which presence you sign the agreement at the registration office, and that's when the agreement is taken into consideration. So I think that is what mostly an leave and license agreement is. And I gave you an example of a residential leave and agreement. So overall, I think I've mostly covered everything. The only one thing that I would talk right now is the letter of intent before entering into any agreement or any sort of instrument, especially with a leave and license or commercial aspect of it. A letter of intent records the understanding between the two party, and a letter is of intent is also known as a letter of interest, which kind of gives the other party an intention what the other party is interested in the business negotiations, and to intend that they want to finally purchase the real estate agreement. Now, real estate letter of intent outlines again the broad terms and for negotiating a final agreement, and the clauses that are there in the agreement, the operative part. The letter of intent makes it easier to fill it out, because in letter of intent it's already recorded what is the lock-in period, what is the payment, what is the alterations, what is the security deposit, when you have to leave the property, what is the notice period as in if you want to terminate the agreement, when and how can you terminate it. So letter of intent forms the base of an agreement. You record all the commercial understandings, and when you actually draft an agreement, it helps you, because in the recital clause you recite the basis of the property, in an operative clause you actually put in the commercial understanding which is recording between the two parties. So that's all from me. I hope it was helpful, and you guys understood. If you have any questions, we can definitely move on to the question answer round right now.
Thank you so much, ma'am, for enlightening us about so many various things, inclusive of Indian Contract Act, the easement, real estate, and everything in relevant context with the current scenario of India. That ma'am, in spite of her busy schedule, took out time to engage this wonderful, thought-provoking session all the way from London. So thank you so much, ma'am.
It was a pleasure. Were you guys audible? Like, was there any technical issue from my side?
No, ma'am, not at all, ma'am. We were observing it from all the ways. We are really sorry for the inconvenience caused. But then, as we say, it was a unforeseen event. But we really enjoyed the presentation. I hope all my dear friends also have enjoyed the same way. So now I request all my dear friends to kindly engage in an interactive session with ma'am. So those who all have questions, please feel free to put them down in the chat box. Guys, any questions? Okay, so ma'am, we have a question from Adarsh Kumar. He has asked, which courts or tribunals have subject matter jurisdiction over real estate disputes? Which parties must be joined to a claim before it can proceed?
Thank you, Adarsh, for your question. Now, when we talk about the courts and tribunals, every court and tribunal, every court, I would say, and not every tribunal, would have access to the matters with respect to the real estate property. But mostly when it comes to jurisdiction, you see where the property is located. For example, if my property is located in Madhya Pradesh, then the courts over in Madhya Pradesh will have jurisdiction, because property law is something which is very specific. Every property law will be governed by the land which is covered across it. But right, when you go to Navi Mumbai, different laws are applied. When you are in the South Bombay, different laws are applied. So it's very zonal. So it really depends where your property is based, then the courts that are surrounding towards it, and also what kind of zonal laws also apply, and which parties must be joined to a claim before it can proceed. What type of transactions are we referring here? If I'm referring to, for example, a party suit where there are a lot of people having an agreement towards the same builder, then every party can join. But if you are not a legal title owner of the property or anyway connected to the property, you cannot go ex parte or you cannot go as an observer. You need to have a specific interest in the property before joining the claim that could be proceeded. So I hope it answers. Talk about 70:30 ratio. What happens is you pay 10% of the advance payment on the total amount that has to be paid to buying a property, right? So what happens is when you pay the 10%, the promoter is entitled to the 10%. Now, what the promoter does with the 10%, it's kind of your right to know, because it's your money that you're investing. Now, initially, before RERA, what had happened is there was no clue as to track the expenses, what the promoter is doing with the money in general. Like, he could take the money and he could run away, or create some kind of fraud or invest that money into something else, where you're paying the money as an allotee to invest it into the project to build a house, right? It's an allotting money in a way. So what the state came up with is you to follow 70:30 ratio, wherein 70% of the total allotee money you deposit into a scheduled bank, and the 30% you can keep it in the hand in order to use it in case of the mere expenses or some expenses that are not explanatory. On day-to-day activities as a promoter, you have to incur it. So 70% of the amount which is already deposited in a scheduled bank, what happens is if I'm taking out suddenly 1 lakh rupees, I have to give a reason why I'm taking it out. It could be I want to pay the stamp duty for this property, or I want to invest this money to, like buy some materials for the construction of the property. So the 70% of the amount of money which is already in a different scheduled bank, every withdrawal accounts an explanation why you're withdrawing it, and you know where your money is invested. And the 30% kind of, you don't have an idea, but it's mostly assumed that it's used for day-to-day transactions. So buyer gets a confidence, okay, this is my money, this is why he's taking out, he's putting into projects, so he's getting back the money also, and he understands the transparency. So this is the whole 70-30 rule.
Like, when do we need to use condition subsequent and condition precedent in the contract drafting?
Yes. So condition subsequent and condition precedent. Now, as the name says, precedent as in like before drafting the contract, and subsequent is after, right? Now, for example, I'm buying a house, and in that house, for example, there is no means of light in that house, right? I can't stay in that house because there is no light or there is no electricity. So I'll put down in my contract saying that the condition precedent is for me to buy a property to fix the lighting, to figure out what are your issues are with the local authority, and give me an access to, occupy the premises in a comfortable way. So that would be my condition precedent. Condition subsequent could be, for example, I'm buying a house in a project, for example, which is still building, right? And I haven't had an access to the house. I have all the amenities, but in my document, it's written that in my building there will be a gym. Now, gym is not an absolute necessary, but you have promised me a gym. So that would be a condition subsequent, because once I've bought the property, you're promising me that sometime after, near in future, I will have a gym. It is a condition subsequent because it will come after the transaction, and precedent is something which is very necessary, which kind of makes it impossible for you to move ahead with the transaction. So this is the simplest example that I could think about.
Thank you so much, ma'am.
There's a question in the chat box before anyone else proceeds. I think the question here is by Mudit Trivedi. So the question is, what will be the procedure if that 70% is not used for the said purpose or is allocated for a different purpose or use? Are there any foolproof ways to avoid that?
This is a very nice question. So, as I said, RERA comes with the authority that it has to be transparent, right? So, when you deposit the money, the promoter deposits the 70% of the money, the promoter will not do it, because every time you make a withdrawal, you have to accord the reason why you're withdrawing the money. So if you are saying that you are withdrawing to buy these property materials required for construction, then you will also have a receipt, right? Kind of validating that proof, which says that you have withdrawn for this reason, and you will have a receipt kind of validating it. So having said that, fraud with the 70-30% ratio, as far as I have known, is not much in the market, because it's a very huge responsibility. When I can see you are taking out the money, I can see in the bank statement that your name is against the money. So how will you justify that you did not take out the money? So it's kind of a recording of an evidence, and that's why you can kind of create some fraud with the 30%, because there is no expenses that are accounted for. But with the 70%, it's mostly unlikely to do it, because everything is literally transparent. I would definitely suggest after the session, you guys should definitely go to RERA website and just pick out any real estate project around you or any buildings names and put it down, and the name and every information will come. Like, you will literally know what is an agreement for sale, because they will upload a document, draft document. You will know what is an OC. You will literally able to understand where is the project at the moment by the documents that the documents that are uploaded. And once you are registered as a promoter, it kind of gives an authenticity, because RERA tribunal makes a very thorough cross check before registering any project or any builder or promoter online. So right now the transparency check is very valid. So the fraud and everything is kind of going lesser. I wouldn't say immediately you will see any changes, but I think eventually you will. I think there's one more question with Adarsh. We are aware that the non-residents can deal in real estate in India. Yes, but which law specifically governs this very transfer? Is it real estate law or transfer? With respect to non-residents, I wouldn't say it's real estate law or transfer of property. Mostly, the real estate transfer of property comes into question because the property is based in India. As I mentioned, when you deal with the property, it's very important to understand where the property is located. Now, even here, the entity is NRI, but the property is located in India. That is why it would be governed by the Transfer of Property Act. But the registration process is something which kind of differs because the person is not residing in India, he's residing outside. So how do you proceed ahead with understanding and registering the property is what it will depend. And FEMA also kind of comes into question depending on what kind of property you're dealing with and what is the purpose. Like, is it purchasing, selling, or is it on a more commercial or real estate level? So, but as long as the property is in India, transfer of property will always be included. There's one more question. We have seen so many cases wherein the buyer has made the payment or continues to pay the EMI for home loan owner, however, no. So with this very specific question, again, this is not legal advice. I'm just giving it out for information purpose only. What happens is once a property is tied in a legal dispute, you cannot kind of deal with the property because it's with the law and it's under the law. So it makes it impossible for you to kind of take the possession of the property immediately. Now here the factors would vary is why is there legal proceedings involved, and secondly, with respect to the EMI, when you sign the document, there are some what do we say, terms and conditions which are recorded for example, termination of EMI. So I'm pretty sure there would be a clause in the circumstances in which an EMI can be terminated. So you have to go through the contract, understand what are the clauses that you have signed up for, and also understand when can you terminate paying the EMI in spite of there is a home loan. So I'm pretty sure if there is a home loan, there will be a mortgage deed as well. So you need to see the documents and find the specific clauses and understand under what conditions you can stop or you can start paying the EMI again. I think I think this should help.
Thank you so much, ma'am.